additional two presenters from other panel focusing on digital security joining us. We are still waiting for them. They are still on their way here. While the original topic for this panel is terrorism and state policy on human rights. The additional speakers, we can relate the topic here through the theme of security and human rights. For this afternoon's panel, we have four speakers. Three are here with us, and one will do a pre-recorded presentation. The four presenters are Saksi Watwa, and then Bayu Dardias Kurniadi. Please for Bayu Dardias Kurniadi to take your seat here with me. And please give some applause for the presenter. And then we will also have Lia Wulandari and Adam Paulsen. They are still on their way from the auditorium from the fourth floor. And each of the presenters will do the presentation for 15 minutes. And so we will spend about like 60 minutes for the presentation. And then we will continue with about 30 minutes for Q&A. And for the first presentation, we will present you with the pre-recorded presentation from Saksi Watwa titled Social Media and Arbitrary Detention, a New Danger to Human Rights. Can we start with the pre-recorded presentation?
Hello everybody, my topic is on social media and arbitrary detention, a new danger to human rights in Turkey. So the idea is to understand three pillars: the state, social media, and human rights in current context with taking the case study of Turkey. So why exactly Turkey or Turkey? First, because Turkey has been into influx since 2013. First with the Gezi Park demonstrations and then with the emergency that was brought in place after the flooding. Further, they had strict on monitoring accounts, individual accounts. Then the state borders,
Please.
which means that
I didn't know that you're already here.
third bodies like ICCPR, and finally it is the top 4 countries retaining highest number of judges. So all these grounds make them
Sorry, I'm Josh. Nice to meet you.
An important contribution that the paper seeks to offer is to understand how arbitrary detention is carried out with respect to social media accounts, social media posts, which includes even retweeting or even liking certain posts and using certain communication applications. So the paper focuses on these three dimensions: state, social media, human rights, with respect to arbitrary detention and how the contours of arbitrary detention has been changing in Turkey over the years. So the first slide talks about the dynamics between the state and dissent on social media in Turkey. So in 1990s, if you look at the country, they had a connection. The country was witnessing a strong connect between media elites, owners of media houses, and ruling elites. When Erdogan was not in power in those times, in late 1990s, these media houses were very critical of his behavior and his actions. As a leader, they were very critical of him as a leader. But as he came to power, later in 2000s, he changed the entire scenario. Financial implications were imposed on such journalists. They were related legally as well. And finally, he put his loyalists into the media structure, to ensure that he will always be taken in high regard, and there will not be any criticism against his government or any of his actions. So, the recent literature that is available, as slide 2 says, is mostly on the Gezi Park demonstration which happened in 2013 and the failed coup against the government in 2016. So, the scholarship on this topic includes this period and understanding how social media played its role during this period. but there isn't much afterwards, after the failed coup. So during that time period of, between 2013 and 2016, the two major demonstrations, the two major, standpoints, social media emerged as an important source of exchange of information, news, and other sources. And why so? Because the media houses were already in control of the then Turkish government. So that is why social media became an important point of exchange for the people. So transmit trap dynamic is another term which is very much used, which says that when social media is used by people against the government, and government takes up this issue and comes up with new policies that kind of suppresses free opinion on social media, especially with respect to the dissenters. So it is a trap. Another loophole with respect to social media and activism is the big data divide. So not everybody can circumvent government's actions to curb social media freedom, and that becomes a major loophole in dissent and in resistance. So the next slide, illegal route for curbing dissent, reflections on state suspicion of social media, talks about the major laws that have been passed by the governments, not just the Erdogan's one, but the general governments against dissenters, or to really curb free expression. So the first law that was passed was law number 5651, which was passed in 2007, also called as Internet laws. So one of the initial laws to regulate internet, that had various internet terms, and a telecom presidency was an establishment taking care of internet rules, blocking orders, was also found, called TIP. Right from 2007, the first amendment took place in 2014 to protect the individuals from online defamation. So it is important to note the backdrop of this amendment. So just after the Gezi-Bagh demonstration, there were also YouTube expose of Turkish leaders who were involved in corruption scandals. So it is against this backdrop that this new amendment came forth, which allowed data storing for 2 years, and then the rights of access to data to authorities. Again, another important amendment that came up to 6639, Law 6639, was on power of blocking in government hands with a more broader and vague definition. So now they were able to block with more impunity. So then during emergency, a series of decrees of laws were passed, important among which is decree number 671, which dissolved the earlier organization TID and established TID, another organization with the same role that the earlier organization played, which the organization that monitored online activity. Again, the decree also put up a time-based deadline with respect to compliance with government orders, failure of which will have actions from government. For example, 2 hours, the time limit of 2 hours and 4 hours were imposed. If blogging others were not complied within 4 hours, the website would be blocked by the government. Decree law 680 again became stricter, with user identity and activity to be in government's control. Government actually seized it. 2020 laws further strengthened these sanctions, financial sanctions, and bandwidth cut up to 19%, 90% in cases when social media doesn't comply with government orders, and a local representative was asked to be appointed by social media companies by the government in order to have a better surveillance and to have a better access to all the internet data. Finally, the 2022 censorship laws had provisions of imprisonment for false information and on the basis of threat to country security. So all these terms are very broad and vague, the meaning of which lies only with the government. That is what the slide also mentions. So next slide talks about, which is the prominent cases of detention on account of social media activity, talks about the major cases in Turkey where people are detained on the basis of social media activities. So one of the very recent cases occurred in August 2023, where member of parliament of the German Left Party, Gökçe Akbulut, was arrested on basis of a social media posts. Further, in July 2023, 5 journalists were detained, who actually one of them had posted about the Kurdish movement, basically about 17 journalists, 17 Kurdish journalists being imprisoned, while the case that was there against them, being the prosecutor of the case in the case of those journalists, was actually married to one of the judges. So the online information about this was then later taken down by the authorities. So one of the journalists, Adnan, has actually posted about this, who was then detained, along with 4 other journalists who merely retweeted his post. Although the rest of them were released later, not much later, in a day or two. But it is this aspect of their arrest and all those implications with it, like their houses were raided with cameras and one of them was handcuffed. That shows that the matter is serious. Then again, Sihan Ardal, the slide does not mention his name, but was one of the students now in Canada, a doctoral student who was imprisoned for a social media post that had a temporal gap of 2 to 3 years. And then again, no reason was communicated to him. There was flimsy reasons were given. He was later put into house arrest, after which he flung, and after which he flew to Canada, where he was actually studying. Since he was also Kurdish, he was detained due to that. He had relations with Kurdish parties, and he also upheld one of the positions there some time back. So these arrests that involve social media posts and all indicate that the matter needs to be taken into account and studied properly. So for that, the next slide, International Safeguards for Arbitrary Detention, the Working Group on Arbitrary Detention, talks about the international body that takes care of such cases of arbitrary detention. So WGAD, as the full form says, was established in 1991 under the Human Rights Commission of Human Rights, which is present-day Human Rights Council. So, the WGAD was actually made for 3 years. So it keeps on receiving 3 years extensions. The recent being the October one. One of the recent is the October extension that it got, and it is this body that takes care of the cases of arbitrary detention and hears all such cases. So although the resolution 1991/42 under which it was formed does not talk about arbitrary detention, later in another resolution 1996/71 they refer to arbitrary detention as deprivation of liberty. So according to WGAD, non-violent posts detention on non-violent posts are arbitrary, and the success of detainees on cases of detention actually show the rise in number of cases where people are detained on the basis of social media posts. According to the recent cases, the WGAD has actually jotted down and talked about the recent cases of arbitrary detention, where first it observes that the reasons of arrest are not properly provided to the detainees. That is also what happened in Sihan Ardal's case. Then police surveillance during interaction was there. Further, WGAD is trying to understand also the intention of the authorities rather than just the mere the instance of detention. So going beyond the letter, they try to understand whether the government is not satisfied with a particular group and the detention is just, the causes of detention are just mere the guard under which they are playing out. And further, the online media is increasingly being recognized by WGAD as one of the platforms where arbitrary detention is increasingly played out, such as bylock, even the use of app bylock is one such instance. So the next slide that says WGAD recent stance on online freedom of expression is what I have just mentioned, but it also shows 2 important points to be kept in mind. First, states' justification of detention involves terrorism. Why? Because states' definition of terrorism is generally quite huge and vague, which leaves a lot of scope for more and more people to be detained under this category, under the counter detention steps. Second is the imposition of emergency. So special circumstances are invoked during emergency in order to detain certain individuals. That happen quite frequently in Italy. Although Article 4 of ICCPR, International Covenant of Civil and Political Rights, that so ICCPR Article 9 and UDHR Universal Declaration of Human Rights Article 9, both of them talk against arbitrary detention, and they view it as a violation of human rights. Article 4 does allow some exceptions during in observance of ICCPR rights during public emergency. However, it does not allow state to let go of the obligations under international laws. Furthermore, Article 4 also talks about the proportionality test that the states usually forego. So, finally, coming to the second part of this paper, which is quite brief but relevant, and the next slide, which says digital authoritarianism and state-supported online propaganda, talks about state support to online medium in furthering its own agenda. So not just blocking access or surveillance, what states are doing are they are implanting trolls and bots that favor them. So one of the scholars have pointed out minority and political model of online hate speech. So government supports hate speech for those who are dissected. So the general illiberal governments do this. So minority model is when the online hate speeches and online crimes get converted into the physical ones. It's more spontaneous and autonomous, while political model is the more networked government supported model that continues to favor trolls. So since I'm running out of time, would just like to quickly go to the slide just before the conclusion, state and social media trolling in Turkey. So networked authoritarianism and patriotic trolling, two terms that the previous slide mentioned, I'll just connect them with these. So networked authoritarianism basically means authoritarianism in the online spectrum, where the government not only stops or blocks the online access, but allows online access in the more internet. Finally, I would like to end the presentation with the last concluding slide, which says that arbitrary detentions, lack of due process, and indirect punishment in terms of trolling, there needs to be an international condemnation of all of that, which is still limited. Though WGAD's efforts are laudable, more are needed in that direction. Further, temporal gaps and detention, with respect to detention and vague charges of terrorism and extraordinary laws during emergencies and special circumstances should be taken into account. Their intentions should be taken into account while deciding on such cases, and more efforts are needed in understanding how social media is playing a major role in allowing arbitrary detentions, and what all can be done to curb the same.
Yeah, for the next presenter, we have Bayu Dardias Kurniadi. He will present, the presentation is titled Rights Discrimination Towards Chinese Citizens in Yogyakarta, Why Nobody Protests. Bayu Dardias Kurniadi is a lecturer at the Department of Politics and Government here at the Faculty of Social and Political Science, Gajah Mada University, and he's also the head of the study program of Master in Politics and Government. Without further ado, please take the time and space are yours.
Okay, thank you, Mas Joash. Good afternoon, everyone. Can I have a clicker? Yes. This afternoon I would like to present about the racial discrimination in Yogyakarta, that has been here for quite some time. But I have two questions: why there is racial discrimination happening in Jogja, and secondly, why there is no protest, even from the local and the national level. So in Yogyakarta, culturally and historically, this is the special province. The province was formed from the two aristocracies, the Sultanate of Yogyakarta and the Pakualaman Principality. So since the beginning, this is the special province. But then the government gave the special law on Yogyakarta specialness in 2012, that among others specialness, there are one exception for Indonesian province in Yogyakarta, that there is no governor election. So whoever become the sultans will automatically become the governor of Yogyakarta for life, and whoever become the head of the Pakualaman Principality will become the vice governor for life. So that's the first case. So in this case, I would like to talk about what is happened to the Chinese community in Jogja, that they cannot have ownership on land. Instead, they only have what we call it as building right, or hak guna bangunan. So building right is the lower level of the ownership right apart from the ownership right in Indonesia, and they have to be renewed every 25 years or so. So in this presentation, I will talk about the Chinese in Indonesia, the Chinese in Yogyakarta, and a little bit about the basic agrarian law. And then later I will explain about how the Chinese struggle for this kind of discrimination, what is the result, and most importantly, why this issue is not come up at the national level. So the first one, this is the pictures of Chinese in Indonesia. The total of Chinese in Indonesia around 1.2%. The majority is in West Kalimantan. There's around like 30-40% there. Around 6 to 8% there. And also in Bangka Belitung, which is the tin island in Indonesia. So this is concentrated on this area, while others is varied between 4% to 2.25%. But Yogyakarta, here, I don't know. Oh, you cannot. So in Yogyakarta here, so we now here, this is small province. We have around 0.03% of the Chinese community. So the racial, one of my arguments is that the racial ownership on land created the demographic shifting in Yogyakarta that I will explain later. So in terms of the number of Chinese in Yogyakarta is quite small compared to other provinces. Yogyakarta is the second smallest province in Indonesia after Jakarta. So what happened in the Chinese in Yogyakarta since the colonial period, or since the era of the sultanates? So previously, the Chinese community in Yogyakarta was led by what we call as Kapitan Cina, or the Chinese captain. One of the most famous Kapitan is called, have a royal title of Secodiningrat. It means that the Sultanate at that time recognized the existence of the Chinese community in Yogyakarta. The Dutch then created few policies. One of them is that Witgenstelsel. It means that the Chinese community in Indonesia should stay on the certain zoning system. So now we know some areas in Pejaksen, near the Tugu, there's a Chinese quarter there. So the Chinese, if they want to go out, they have to create a pass to go to other areas. So there is a zoning system. The history back to the 1740s when there is a Chinese rebellion in Jakarta that almost create the collapse of the Dutch in Indonesia at that time. So in 1875, for instance, the Dutch then created a policy to prohibit the land selling from the indigenous community to other ethnicities, especially the Chinese, the European, the Arabs, and the Indians. So what I'm saying about this presentation is not merely to the Chinese, but also to the other nationals, the European, the Indians, the Arab. But the one who struggle for their right because of the numbers of the population in Jogja is quite a lot, the Chinese. So the Chinese is the one that is struggling a lot. The sultans also issued the Rietsblad in 1918 that prohibit the transfer of ownership of land to this ethnicity, these four ethnicities at that time. What happened to the independent? One of the proponents of this discriminative policy saying that the Chinese took the side of the Dutch, and then that's why they cannot have own land. But I will explain later about this kind of fact. So in 1946, there was a Chinese registration in Yogyakarta. Among 8,297 Chinese peranakan, or those who born in Indonesia, 60% of them chose to become the Indonesian citizens. So, and then the rest is chose to become both they asked for dual citizenship or they chose to become the Chinese citizens. And then in 1954, the Yogyakarta land bylaw passed, and there is no discrimination at that time. So, in 1960s, we have one of the second most law in Indonesia after Constitution is called Basic Agrarian Law, 1960. And in this law, there is no discriminatory about ethnicity. So basically, the Basic Agrarian Law only said that if you are Indonesian citizen, you can have land. But if you are not Indonesian citizen or you are foreigner, you cannot own land. You only have a certain right other than ownership right. So there is no discrimination at that time, and land title only for Indonesian citizens. Now there's some relaxed this law. So some foreigners can buy some apartment with cost more than 5 billion rupiah, but that's just after the 2020. But basically, the Basic Agrarian Law only differentiate between citizen and non-citizen. The question is why the Chinese can't own land in this province. So this is this panel is talking about the policy, but this is not about quite a policy. This is quite tricky here. So in 1975, the vice governor issued a circular. Circular is surat edaran. So circular is not part of the policy system in Indonesia. And in this circular, given to all of the other district heads, saying that the Chinese or the other ethnicity, Chinese, Arabs, Indian, European, cannot own land in Yogyakarta, but they can only have the building right in Yogyakarta. So since then, the Chinese and other ethnicity cannot own right, even though they are Indonesian citizens. So if they already have land before this, they should return it to the state and then become the state land. And after that, the state will be given the building right to this particular citizens, the Chinese citizen, in those particular areas. So you are following me, right? So so there is no more, since 1975, there is no more transfer of ownership to the Chinese and other ethnicities that I mentioned before. If they already have it, they have to return it to the state, and then the state taken it as the state land, and then the state give the right back to this particular person, the building right. So they cannot have ownership right, they only have building rights which last for 25 years, and then it should be renewed every 25 years or so. So some of them can have loopholes there. So they have the connection in the bureaucracy, the connection on the military during the new order, and they can have ownership right. But after 1998, it's all stopped. So no Chinese here can have land. It's of course, it's again the human right law that we are talking about, number 39, 1999, and anti-discriminatory law number 40, 2008, but has no effect until now. It's still in practice up until today. So, what is there? The Chinese community tried to challenge this policy. They have, first of all, they have to PTUN, or State Administrative Court. They won at the district level, but failed at the province level and failed at the Supreme Court twice. They also challenged at the state court, the Pengadilan Negeri, and then they failed in all of the levels. One of the most interesting things that the result of this court challenge is that the judges stated that the 1965 instruction was not part of the legal system. And therefore, it could not be challenged in court. So, however, even though this is part of the legal system, but it's still in practice. No one dared to challenge it. The question is why? Now, there are also some non-legislation process. First of all, in 2006, if I'm not mistaken, the Chinese community in Yogyakarta sent a letter to President SBY. And we know President SBY never have a committal answer, right? Oh, okay, we will think about it, and then something like that. So there's nothing. And then they asked for the Human Rights Commission. In 2014, the Human Rights Commission issued that, okay, stop racial discrimination because this is against the human rights law. In 2000, but there is no response from the Yogyakarta government at that time. In 2015, the Chinese community asked again to the Human Rights Commission, and the response is quite strong at that time. The disregard shown for the Komnas HAM recommendation has become an indication of systematic human rights discrimination. However, this is the loopholes in our legal system, that the recommendation from human rights has no binding effect. So once
Mas Bayu, you have 3 minutes more.
Okay. Once they have the recommendation and the government, the province governance doesn't apply it, it's okay. So this is one of the problems. This is the quote that I get from the late Hadiwinoto, the Sultan's, is also the governor's only sibling. He said that, I want the Yogyakarta Chinese to remember, do not only ask for your life to fulfill. You live and die in here. If you don't want the policy regardless the land, you can live outside Yogyakarta. So, this is my two last slide. Why there is no response? First of all, people seeing a Chinese community as the have, even though there is a fact that there's some non-have Chinese that I met here in Yogyakarta. So they see this policy as part of this positive, quote-unquote, positive discrimination to prevent the land ownership transfer to the Chinese as similar to what happened in Bali. So they doesn't want that the massive land transformation in Bali. First of all, and unfortunately, the government then issued the government regulation number 18/2021 saying that, I haven't put it in English, basically saying that even though there is a transfer of ownership from building right to ownership right, it's not applied to Yogyakarta. And this government regulation and also the previous court cases has not only failed to treat the anti-discriminatory policy in Yogyakarta, but also strengthening this kind of discrimination because they think, some of them thinking that it's already the court has already put it on this law, on this decision, and it's quite become the stronger and stronger. So, as a conclusion, what is this impact on Yogyakarta development? First of all, you can see that there is a democratic decline, serious democratic decline of Chinese community in Yogyakarta. In 1930, the census in 1930 showed that there are 12,640% of Chinese community in Indonesia, and it contribute about 0.81% of the total population in Yogyakarta. Still, it's below the national average of 1.2%. In 1954, the number reduced to 11,000 because some of them choose to become the Chinese citizen. But in 2010, the latest census shows that the Chinese in in Yogyakarta, only 11,500 people, or 0.32%. So in terms of population, there is a declining percentage of the Chinese population in Yogyakarta for the last 100 years. And one of the effect is that in Yogyakarta, even though the labor is cheap, one of the cheapest in Indonesia, there is no labor-intensive industry because the Chinese doesn't want to invest because they cannot own land. So what's the point? And then the last one, even though Yogyakarta has a lot of smart people, but the life expectancy here is high, but we have the highest Gini index in Indonesia of 0.449. The national Gini index is only 0.38. So this kind of discriminatory policy and the response of the people, I think, shows that there is a strong legitimacy from the sultans as also from the governor related to this land issue. That's why he can implement the quote-unquote non-policy, but it's become a practical policy in Yogyakarta. And the second one, the people doesn't want to protest it because they saw that this is part of this positive discrimination for Yogyakarta. Thank you very much.
Thank you, Mas Bayu, for the wonderful presentation. Yeah, we move to Adam. Yes.
Thank you. Hi everyone, thank you for having me. So I'm Adam. I'm a research fellow from Australia, from Sydney University. And I'm not an expert in human rights or digital rights, but I'm a tech ethicist and a health technology researcher, working mostly with mobile health, or mHealth, which is the use of mobile technologies to help with healthcare. And so today I'm going to be talking about a scoping review that we did. And given that I'm not an expert, I have quite a lot of co-authors, which I would like to acknowledge there. Move forward. Okay, so some background on the study. As I said, it's a scoping review on the mHealth in LMIC's literature, so that's low and middle income countries. The research question was, what digital rights topics have been explored in the 2022 literature on mHealth and LMICs? And so we were looking through the mHealth literature to try and understand how researchers engaged with the topic of digital rights. And for the sake of this conference, we made a case study of the literature that was related to Southeast Asia. I'll mostly skip this. I'd imagine everyone knows what digital rights are. They're existing rights that are extended into the online space, but they're also emerging rights. So things like the right to internet access. In essence, digital rights are human rights. So the sort of areas of interest and how they intersect were LMICs, digital rights, and mHealth. How they're related are, so in LMICs, mobile phones are ubiquitous and they increase people's access to health. Digital rights are at risk in LMICs, and mHealth promotes specifically the right to health, but it also implicates other rights. And the application and use of mHealth is impacted by trends affecting digital rights. These are some of the trends, just briefly, that affect digital rights in Southeast Asia specifically. So lack or restrictive governance related to digital rights, and digital rights violations are quite at risk in Southeast Asia. Things like state-enforced internet shutdowns, criminalization of online expression, and invasive technologies. The methods for the study we did, again, scoping review, we used 6 databases, and the studies had to relate to mHealth in LMICs, and it had to talk about digital rights in some way. We extracted quite a bit of data. Of most interest, though, is the digital rights characteristics. So we were looking to see if the researchers used terms specifically to do with digital rights, so human right, digital right, human digital rights, things like that. The second piece was any explicit digital rights topics cited. So if the researcher specifically cited a human right or digital right in their work. And the third one was implied digital rights topics. So that involved us having to go through the articles and try to understand if they're inferring any digital rights topics. I would go forward if I can. Sure, okay. This is the prisma diagram describing the study we did. We started off with nearly 3,000 articles. We then limited it to just literature published in 2022, which cut quite a bit. And we ended up with 56 total studies. That's for the full review. But then for the case study, next slide, please. Case study, there are 9 included articles that address Southeast Asian LMICs specifically. Next slide. I think I did that. So here's some of the general characteristics, just briefly. So of the included articles, which there were 9, 3 were related to Indonesia, 3 related to Cambodia, and 1 of each relating to Malaysia, Vietnam, and then one last systematic review we captured in our included articles addressed Thailand, Indonesia, and Malaysia. Looking up to see if anyone was doing any sort of helicopter research, we did see that some of the first authors were located in countries outside of Asia. So some in USA, some in Australia, and Germany. Of the study designs of the included articles, there's no sort of general consensus, but there was some RCTs, randomized controlled trials, qualitative research, systematic reviews. It's kind of all over the place. We also captured the mHealth characteristics in the included articles. The most common ones were, for the health area that was being addressed in the included articles, was community health and health education. They were the focus of the articles. But there's other ones addressing health promotion, sexual and reproductive health, global health. The most common form of mHealth technology cited in the included articles were smartphones, phones in general really, because there are also a lot in feature phones, and some cited some non-specific mobile phones. The numbers don't add up to 9 here because some articles mentioned multiple different technologies. In the included articles, the mHealth functions focused mostly on smartphone apps for mHealth purposes, but also some SMS usage, audio clips, so like sending audio clips to people's mobile phones to help with health promotion and things like that. The purpose or the application of the mHealth was mostly for client education and behaviour change. So that's things like reminding people to take medicine on time and things like that through apps or through SMS reminders. There's also some articles that addressed provider to client communication, so maybe calling up clients of health services for whatever reason. Data collection and reporting was coming up a lot in 4 of the articles, and so that was the use of mHealth to conduct research or collect health information. The target users of the mHealth were mostly the general public, which is good to see, and that seems to be correlated to the rise of smartphones, using smartphone apps for things like self-care or educating yourself on health, things like that. Okay, so some of the results related to digital rights. Most of the included articles did not cite digital right, human right or digital human right at all. only a single article mentioned the words or the term human right specifically. And that was this article here. It's out of Indonesia, actually. And basically they just mentioned that health is a human right. For the explicit digital rights topics that researchers cited, empowerment came up the most. So just a reminder, this is a scoping review of digital rights topics, not specifically rights themselves, which would be more like freedom of movement or right to privacy, right to health, which are also came up in one article, but empowerment came up in 3. Here is the 3 instances of empowerment that came up. So 3 different conceptualizations or meanings of empowerment, sorry. Community empowerment, health patient empowerment, and women's empowerment. Here's just a few other examples of the explicit digital rights topics that researchers mentioned. So freedom of movement, the researcher was mentioning how mHealth interventions can reduce gender-based barriers such as spousal permission, lack of freedom of movement. And another article was focused on the digital gender divide, so it had 3 different ways of describing that. And for the implied digital rights topics, which sort of required us to go in and try to understand what the researchers were trying to say about digital rights without specifically saying it, of those topics, the right to health came up in every single article, which makes sense because it's about mHealth. So usually mHealth is promoted as a way to realise your right to health. In 6 instances, solidarity and inclusion came up. In 3 instances, a fair digital environment and the right to social security came up. There's a few other examples there. I sort of want to explain how we made those inferences. So through just using the ladder of inference as an analytical technique, we took an excerpt from the included study, and then you can make an inference about what the researcher was trying to say, and then that leads you to the implied digital rights topic. Here's an example. So in this study, it was about using mHealth, specifically using SMS reminders, to educate female entertainment workers in Cambodia about the dangers of excessive drinking at work. And so the inference we're making is that the mHealth intervention can improve safety and health at work in this way. And that implies the right to safe and healthy working conditions. Another example we did here relates to the right to internet access. Basically, the researcher was saying that mHealth, or access to information via mHealth, enables you to take care of yourself better, and that is only enabled if you have a right to internet access. A third example, so solidarity inclusion, it's a very specific sort of term used by the EU in their recent Declaration of Digital Rights, which was just last year, I think, or might have been signed even this year. And we found that as one of the implied digital rights topics. So the purpose of a scoping review is to sort of try to map out the literature, to try and understand what the gaps are and what's being done, and to try and recommend ways forward. And so here's the gaps, or the boundaries, the current boundaries of the map of the mHealth in LMIC's literature. Basically, engagement with digital rights by researchers is sparse, sporadic, and unsystematic, hence why we had to make so many inferences. And some of the reasons why this might be, this is just a preliminary study, so we're still working on this.
3 more minutes.
How many, sorry?
You still have 3 minutes.
Thank you so much. So the reasons why digital rights topics are so sparse in the mHealth literature is digital rights, or human rights even, are often associated with Western individualistic ethics, which might not get along with the meaning of human rights or digital rights in Southeast Asia. And in a similar way, the definitions around it are unsettled currently in Southeast Asia. There's a lack of policy and research funding, and thus a lack of research attention on digital rights in mHealth. And lastly, there are no researcher guidance in this space at all. So now that we know the gaps, what's the way to move forward? How do we push the boundaries of the research at the moment? 3 ways to basically fill those gaps. So advance the definition of digital rights and its relationship to human rights in Southeast Asia. Develop methods and reporting standards for mHealth research so you can account for digital rights when you're doing research and build them into your designs. Something similar would be like in healthcare. People use human rights based healthcare approaches using reporting schemes when they're engaging with human rights. And so we could do that in mHealth research as well. And the last way is to engage more specifically with codified rights instead of having to require me to make inferences about them, and specifically with the rights of Indigenous peoples, which none of the studies did whatsoever, despite working with Indigenous communities. And that's it. Feel free to connect with me if you like. I'm happy to work with anyone. Thank you.
Thank you, Adam. The next presenter is Mbak Lia Wulandari. Please, the time is yours.
Thank you, Pak Joash. I'm sorry for my voice because maybe my body refused to work in vacation city, so I got sick when I come here. Okay. Today, I will present, actually this is my research with Bayu, with Bimo, and with my friends, my colleague from San Benil, Philippines, Sheila Sabalburo, and then from my friends also from BRIN, Devi Darmawan, and also one of our colleagues, Ibu Restu Rahmawati, but they cannot join us today. So I will be the one that will present this. Actually, if I can be honest, we still have some lacking in interviewing some very, very important stakeholders for this research. That's why our data is very raw and dusty right now. And with my half brain working right now, as you can see, it's also very messy. So actually, why we're doing this research, not only because I have friends from Philippines. No, it's actually because in 2022, Indonesia is very sad. No, Indonesia still don't have any law to protect our personal data. We just have the law in 2020 September. 22, I mean. See my brain. And because of I was a part of the NGO coalition to push the government to right away, please make this law happen and so on. Because we already drafting the law since 2012. And other countries like Malaysia, Singapore, Philippines, they already right away make it happen. But in Indonesia, we need 10 years to make it happen. That's why I was thinking that I think we need to learn from our neighbor country, then coincidentally, I have a friend in Philippines. And then, why we also doing this research? Because kayaknya nggak jalan lagi. Because as Indonesian, I was very bored every day. Unknown number, scammer, keep calling me and asking me to join them something. And then how can they get my number easily? Not only my number, all Indonesians have the same SMS, even no WhatsApp. How can it happen? Until now, even though we already have the law, that's Indonesian. That's why we think that this research is very urgent to do in Indonesia. And when we do the comparative studies with the Philippines, they already have the law since 2012 right away. And they also have the National Privacy Commission after the law was passed. And after that, they also have implement all the articles of the law very in a good way lah. Because my Singapore, because all the people that I have been interviewed from the Philippines thought that even though some of them want to become anonymous, they said that for this law, actually, the Philippines is doing good or better lah than Indonesia. Then, Indonesia, in our law, we have sanction or fines. It's also, there is a law, they also have punishment. We have punishment if the law is violated, if someone, or if right now you share my number easily, you can be fined and you can also be jailed in the prison. Even though whoever you are, even though I share your contact with you when I register this conference, but now you can be fined. But unfortunately, not really, the implementation is still very lacking in Indonesia because we still don't have until now, even after more than 1 year, the law already passed and also the discussion and all the the meetings between the legislative, the executive, the president, the ministries, they still have so many interests in the making of the commission. Every ministry, every stakeholders in the government institution, they still want to get the power to give the sanction. Because, why? Because they have these fines. And it's also because they want to control it. They want to have the control in this regards. Because they also, the critics from non-government organization in my coalition, actually this law also have the other loopholes. Because, like for example, we will have election next year in February. If we share about someone that corrupt or they have doing criminals record, is also part of the personal data. And the person that share it also can be fined too. So it's also become one of the critics. Why, if you want to run for election, if you want to the people to vote for you, you're supposed to socialize about that, right? But then in Indonesia, they want to have a good image and so on to be, and they tend to keep it buried if they have criminal records and so on. Even they also buy some certification for education that fake, something like that. So yeah, it can be if like, for example, if I working for anti-corruption organization and so on, and then I want to publish, this is all the corruptor that want to run for the election. This is their district, something like that. In every election, actually, we always share that very easily because it's a part of public information, right? But because of this new law, all the organization can be in jail and can be get the fines because of that. And then, oh kenapa mundur? Okay. Another comparative studies, maybe I can share about the case, how the National Privacy Commission in the Philippines, they handle the case that data leaks that happen in the Comelec or Commission of Election in the Philippines in 2016. Their voter registration data has been leaking, and then right away, their National Privacy Commission, they have very fast response about that. And they also have processing right away all the penyelidikan. Nggak apa-apa mas, ntar malah saya batuk kalau. Kayaknya ini harus di steril habis saya deh, takut kena bakteri. Oke, terus. Oh yeah, and then they also give the fines or sanction to the people that caused that happen. Because apparently the case is happened because one of the staff of Comelec lost their phone because of it's stolen. And then all the voters registration data system is inside the laptop. And then after that, thankfully, he right away reporting to the NPC, but then that person right away get the fines too because of that. This shows how their NPC or commissions work.
You have 3 minutes, Mbak.
Yeah, okay. And meanwhile, in Indonesia, kayaknya terakhir aja, Mas. Nah, kalau in Indonesia, we have so many data leaking, includes our election commission, includes our health, Ministry of Health and so on. Okay. Ya, silakan lanjut. Oh. Yeah, and like what I have mentioned before, they don't have any procedure until now. Even they don't have any technical regulation until now. How to implement the law, who's gonna have the authority, who's gonna give the sanction and so on, because all the stakeholders keep trying to get the power like that. So that's what happened in Indonesia. I don't know, do we still have to wait for new government after election or what? Hopefully next year they will have the new authority, maybe under new president. Yeah, maybe that's almost just.
Yeah, thank you, Mbak Lia. Thank you for the wonderful presentation and your determined effort, despite you not feeling well, to do the presentation. Now we can continue with the Q&A session. I'm opening opportunity for 3 questions for the first term. Yeah, 1.
Thank you for the presenter. I really appreciate the presenting. I want to ask to Mbak Lia, because I'm so sorry, Mbak, but I'm curious about your opinion about this one. Next year we will face the general election. It means there will be a lot information that might be hoax, and the youth might be vulnerable in this problem. So mirroring back then in the Philippines general election, there was a propaganda, like the Federal Marcos, like Terrorism, won the election. But right now, I just want to ask about what should I do as a youth generation to prevent the hoax, and also what should I do also to make the election next year will be a more good and healthy election. Thank you, Mbak Lia. What should I do as a youth?
Ya, terima kasih Mas Hasto. Ya, mau langsung do you want to answer it directly or?
I want to ask.
Okay, yeah, please.
Okay, thank you for the presenter. I really appreciate about the research. My name is Alexandro from UPN Veteran Jakarta, and I have a question for Mas Bayu for your research, regarding your research. I was just curious, is there any response from the civil societies in Yogyakarta about the ongoing discrimination on Chinese minority people in Yogyakarta? Because I think it's important to initiating a civil society movement, because from what I received from your presentation, I think it's very critical, or it's very hard to unravel these problems. Nah, that's my question. Thank you very much.
Thank you. Another one? If no question, I would like to ask a question to Adam. Adam, in the literature that you reviewed, have you found anything with regards to the topic that Mbak Lia just presented about data security, especially related to medical data? Because I think that is one of the most prone data to leaking. Yeah, I think that's my question for Adam. And can we start with Mbak Lia? Can you still make it? Are you sure you're going to survive after this panel?
Please don't have sympathy for me, because I have too much fun last week here. That's why I get karma now. Okay. Why? How do you know I working on election? Okay. This is what become our very important issues too that we always highlight with other Filipinos and also other university like UPD Liman and San Benilde, and also with the scholars in Indonesia too, because you know what happened now. Even as a finger fighter, I always put comments in Instagram or TikTok whenever someone mention about that. Actually, they have so many hoax happen, they said there. And then they also involve so many influencers too without any that been paid to campaign for the other candidate. Meanwhile, the other candidate that they thought that will be the winner, she doing some very different strategy in her campaign. So after that, actually, when I discussed this with the students from the university, they actually know what's going on. And they also, most of them also not really choose for that one. But then, it's not my country. But then, because what happened today in the world with the recession after COVID and so on, and with the system, political system, election system there, so who win the election, you know, who got the money. That's what happens. Hopefully not something happen to the same way in Indonesia, yeah. Hopefully. But what I'm afraid, like what happened recently, because even some of my students too, they also started to involve in the campaign without really realize that it's a part of political parties' campaign. Yeah, that's the what become my biggest worries. At least we still have to keep them keep them realize that, and then keep them in the discussion, not only in the class but also informal with them about that, because even some of the people that said we are alumni, they also trying to get their influence to their younger generation and so on, and it's really concerning too. Cari teman yang baik.
Okay, thank you for the question. I think this is quite very important question. Yogyakarta is the home of the activists. The 1998 Reformation, some of them start here. And the question is why this kind of issue is not come up and support by this NGO in Yogyakarta about the discrimination. Well, this is my hypothesis. First of all, the one that don't have rights is the Chinese, and they are minority. So if those who doesn't, in my opinion, if those who doesn't have right to own land in Yogyakarta is indigenous community, the case would be different. Backing up or have an activism for the Chinese is something here. Not only in Jogja, I think, it's for Indonesia in general. So they are already presumed as they have a high level of economic income, and that's why being asking for their right is not quite popular in Indonesian activism history. That is one of the problem. In my opinion, that's one of the explanation. However, those Chinese community, they try to have their own organization. It's called Forpeta NKRI. I forgot the abbreviation, but basically they are asking for their similar right as the Indonesian citizens. So that's the first activism. The second the second reason why this issue is not come up at this civil society level is because the one that they face is the governor and also the sultan. So in Japanese term, there's kind of Japanese culture that prevented. We are not supporting the sultans because we don't have that kind of history. For the fact, Yogyakarta is quite a monolithic province. 97% of the people living in Jogja is Javanese. Okay, only 3% is coming from other ethnic. And maybe if we look at the genealogy, we have the 10 sultan, and some previous sultans has a lot of wives. So maybe if we don't have, I have a calculation correct, one of my colleagues from Australia have make some calculation. Maybe like 20-30% of the population in Jogja is descendant of this king, of the sultans in the past. So if not, they have the relation who work for the sultanate. So that's why it's not become quite a common issue in Yogyakarta. It's not polite to, to face the sultans, which also the governor for life. Maybe that's the two reasons why this kind of issue is not quite popular in the Indonesian activist movement, especially in Yogyakarta.
Yeah, thanks for your question. So relating to sort of data security and data breaches, leaks, things like that, of the included articles, those which were empirical studies that required some sort of data collection, yes, like we can infer that based on the researchers talking about requiring safe data collection and storage, that the right to privacy is something that's important. One study specifically mentioned that they were doing so in order to ensure clients or participants' right to privacy. They specifically cited that. I do recall that. Only in a positive sense, not in a negative sense of like, oh, there could be some sort of data breaches. No one mentioned those things. Sort of by extension of the right to privacy, one study was addressing gender-based violence, and they were using SMS messaging to contact women at risk. And in order to advance sort of the right to privacy, they were sending messages that had a sort of deceptive lead-in, so that if any sort of anyone else was looking at their phone, the first line doesn't come up as like, hey, this is someone contacting you because you're at risk and you have a violent partner. It was more like, hey, how you doing? How's your day been? And then it would lead into more, here's some information you can get in order to help you, in order to ensure their privacy and by extension the security of the person. Yeah.
We still have around, no? Okay. Yeah. I mean, like, I still have some more points to ask, actually. But yeah, I mean, like, we have limited time. And I would like to thank the presenters here for the wonderful presentations, and also the audience for attending this panel. And hopefully we will meet again, like in the panels and the plenaries tomorrow. It's already 5, so yeah. Good afternoon, everyone. And before we close this panel, let's give our applause to all of us. Thank you.